Well, of course, the big story this afternoon still former President Jacob Zuma's lawyers arguing in court that the prosecutor, the advocate Billy Downer, should be removed from the case, that he doesn't have what lawyers call a title to prosecute. Also, a claim essentially that Downer was trying, well, too hard to prosecute Zuma. They've pointed to how, when the spy tapes emerged, Downer argued that the case against Zuma should continue. At the time, the acting head of the NPA, Advocate Mokotedi Mshiya, decided the case should not continue. Kelly Phelps is a senior lecturer in the Department of Public Law at the University of Cape Town. Kelly, good afternoon to you. I mean, I have to start with this. What is a title to prosecute?
Well, it's interesting you asked the question, because it seemed at certain points during today's proceedings that the judge himself was asking the same question. This is a section of the Criminal Procedure Act that really has not been used very often at all. I could only find 2 or 3 cases in the books where it's been argued. So there's really not much we know about it. What we do know is that previously it's been interpreted technically and narrowly. So in other words, to mean, has the person been appointed through the correct channels, in that they have the standing or authority to act as a prosecutor? But we don't know whether it is capable of being more broadly construed, as Mr. Zuma's legal team is trying to convince the court that it should be.
I mean, Billy Downer has been a prosecutor, I don't know, 30 years maybe? He was the deputy head of the NPA in the Western Cape.
Absolutely, and it's quite clear from the papers that Mr. Zuma's defense team have submitted thus far that they are not arguing that he has been inappropriately appointed, that he doesn't have standing as such, but rather that the fact that they are claiming he is biased towards this prosecution renders his standing null and void, that he doesn't have title to prosecute because he lacks the impartiality that is required of a prosecutor under their oath of office.
Okay, so the argument comes, essentially, the lawyers will put this in Latin, but the argument comes that Downer was trying too hard. And this gets very complicated, but at one point in all of this, what's called the Zuma spy tapes emerged, and they showed that in 2007, a former head of the NPA, Bulelani Ngcuka, was discussing the timing of the decision to charge Zuma with the then acting head of the NPA, Leonard McCarthy. This was just before Christmas in 2007. Now, what this meant was that Zuma then took these Zuma spy tapes, as they were called, to the then head of the NPA, Mokotedi Mshiya, and said, look, this was proof of misconduct among the prosecutors. It's a very complicated saga. It went through the Supreme Court of Appeal, I think, twice. In the meantime, at one point, Downer was asked for his view as the head of the prosecution team, and he said that in his view, the prosecution should continue. Now, Zuma's argument, as I understand it, is that this shows that he was not just motivated by justice. Is that enough evidence that Downer was pushing too hard?
That certainly wouldn't be enough evidence. We would expect a prosecutor, when they are using their discretion to prosecute, that they do feel very strongly about their prospects of success, because after all, it would be a waste of public resources, of taxpayers' money, if prosecutors proceeded with cases that were on a flimsy basis, that they didn't think there was a strong prospect of success. But it is notable that in Zuma's papers, Mr. Zuma's papers, that's not the only ground that they're claiming bias. So, for example, they're using allegations of Billy Downer's interactions with the media. They're using allegations of Billy Downer's interactions with intelligence operatives and his undertakings to the prosecution service, or his persuasion of the prosecution service to pursue the case. So all of this needs to be considered in a whole in order to evaluate their argument that he is biased, that he lacks impartiality. Each one of those grounds of their case is taken together in order to try and prove on their behalves that he is in fact biased towards Mr. Zuma, and therefore that Mr. Zuma's fair trial rights would be irreparably harmed.
If I remember correctly, Kelly, and I've never studied law, so I have a journalist degree in law, if I can call it that. The decision about whether or not to prosecute a case is, does the prosecutor believe there will be a conviction? That's the only question, really. So if a prosecutor believes there will be a conviction, they're not going to suddenly change their mind because, audio tapes emerge.
Absolutely. I mean, reasonable prospects of success are the legalese for what you're describing there. That is the standard that needs to be met in order for a prosecutor to pursue a case. So the emergence of these spy tapes would not be the only reason on which a prosecutor would suddenly abandon a case that is extremely complex and that is built on extremely substantial evidence from various quarters. They, in fact, not only would it not be proper for them to abandon it on that basis, but they, I would argue, would be it would essentially be abandoning their duties to pursue justice for the public, because where there is a strong grounds for success, they must pursue that case.
How do you expect the state to defend Downer? I mean, what do you expect them to say? They're, I presume, going to sort of say, look, it's just not reasonable to remove the prosecutor.
Well, I mean, there's a number of grounds that they are likely to raise here. First of all, they're going to be looking very closely at the further papers that are submitted by Mr. Zuma's legal team. They've already stated outside of court that they don't believe that Mr. Zuma's team have provided any evidence of Downer's so-called bias. After all, there's a big distinction between an allegation and evidence provided to support that allegation. So they'll be looking very closely and scrutinizing the papers in that regard. But I think primarily, actually, what they're going to focus on initially is going to be a technical argument under Section 106 of the Criminal Procedure Act, because, as I've mentioned already, this is not an often used section, and the cases in which it has been used don't correlate with the circumstances under which Mr. Zuma's legal team are trying to use it in this case. Specifically, there's a Supreme Court judgment from 2015, which is called Porritt, and they mentioned it in court today. And although the facts of that case are not identical, they're very similar. And that was another case where they tried to argue that because of bias on behalf of the prosecutor, amongst other arguments, that Section 106 should be invoked and an acquittal should be secured. Now, the Supreme Court of Appeal in that case declined to consider the question of bias under Section 106. They actually separated those two issues out and said Section 106 was more technical and the question of bias had to be considered under the common law rules about recusal. So there has been another case where this has unsuccessfully been attempted, and Mr. Zuma's legal team are going to have to put forward very persuasive and novel arguments to convince this court to take a different route in that respect. And I imagine the prosecution will be trying to make the most of that and will really be going out strong to argue that this entire application under 106 is in fact ill-founded.
One of the items quoted in court by Advocate Dalian Pofu, acting for the former president today, as I understand it, is a series of guidelines for prosecutors from the United Nations. Now, I remember in our law there are some judgments that have literally looked at treaties that we've signed up to around the United Nations and taken them very seriously. I presume a judge would take these guidelines around prosecutors very seriously.
Well, I'm pleased you raised that, because this was something that struck me as well when I was following the proceedings this morning. I'm quite surprised the extent to which his legal team are arguing these guidelines. The reason I say that is that one has to look at the status of any kind of international law in our own law. Our courts are obliged to consider international law, but not all documents that exist in the international sphere have got equal status or binding power. So guidelines are just that. They are guidelines. They're not binding laws that produce an enforceable duty upon local courts. So I would have thought that they would first be trying to cite binding legal documents that place a duty on the court to decide in their favor, rather than reaching for mere guidelines that really only are of persuasive or instructive value, but don't actually instigate a duty on the court to follow them.
I suppose, Kelly, no matter which way we look at it, and I'll be very cynical for a moment if I may, the one consequence of all of this is a delay. We're not going to have witness testimony for some time.
Yes, absolutely. It's hard to tell at this stage how long that will be for. I mean, strictly speaking, officially today, because the pleadings happened and we saw Mr. Zuma plead not guilty and Thales plead not guilty, the trial has officially started. But in terms of the trial proper, there is really a substantive delay, because this will be a matter that has to be ventilated and fought out before we can proceed with the primary issues that are the subject matter of this trial. Hopefully, the delay will be curtailed. And I think there were some promising signs from court today of that happening. One thing that struck me was the firmness with which the judge actually conducted today's proceedings. It was very clear that he is completely committed to being demonstrably fair and balanced to all parties involved and giving everyone an adequate opportunity to air their arguments. But equally, he was not at all scared to pull people into line and to remind them that he will only entertain arguments that are directly relevant to the matter at hand. And I think that bodes well for curtailing the ongoing delays that we've experienced in this matter.
Kelly Phelps, thanks very much indeed. Senior lecturer in the Department of Public Law at the University of Cape Town. I do appreciate the time.